2. Monopolies. 2.1. Monopolies in fact or in law. Libertarianism is a theory of law, a theory of what is or isn't lawful to do, of how we can organise such knowledge into general rules, of how we can discover such rules, of the ways these rules differ from the rules of morality, etc. It is conspicuously neutral as to the goals that people seek, and to the results that they reach, except inasmuch as it denounces some goals as doomed to fail because they contradict nature, or even themselves, whereas it gives hints as to the means that can or can't be used so as to successfully achieve other legitimate goals. Therefore, as far as identifying monopolies is concerned, as well as for making any judgment on the lawfulness of anything, libertarians will carefully distinguish between criteria that involve means of action and criteria that involve goals and results. Libertarians thus distinguish the relevant means-oriented concept of monopolies in law, or de jure monopolies, from the irrelevant ends-oriented concept of monopolies in fact, or de facto monopolies. Criteria based on facts, goals, and results define monopolies in fact. There is a monopoly in fact where there happens to be only one provider for a certain class of services or products. To a libertarian, there is nothing to say for, against, or about monopolies in fact. They could be judged morally as good or bad, but this all depends on the considered alternatives, and is a matter of individual morality. Criteria based on law and other legal constraints define monopolies in law. There is a monopoly in law when laws, or any kind of rules enforced by the use of public force, establish a monopoly by preventing customers from seeking providers not blessed by the political power, or equivalently by preventing potential competitors from providing services that compete with those from the protected provider. To a libertarian, such laws that promote a de jure monopoly are an assault on the liberties of consumers and competitors, even when they fail to result in a monopoly in fact. It is remarkable that classical liberal authors have always used the word monopoly only meaning what I now have to qualify as de jure monopoly. It is statists who have corrupted the word into meaning something altogether different and meaningless. Remarkably, the word for libertarian at the time, early 19th century, was economist, which word has also been stolen and corrupted by statists. The process is similar to that described by George Orwell in 1984. Statists corrupt words and remove their meaning, so that people become unable to clearly formulate objections to the state's intervention. 2.2. The irrelevance of de facto monopolies. Actually, post facto, in retrospect after the fact, every transaction involves a unique producer and a unique consumer, and thus is both a de facto monopoly and de facto monopsony. Whether other transactions for similar services involve the same producer or not is irrelevant. Indeed, by choosing appropriate definitions of similar for services, one can establish either the monopoly status or lack thereof of any firm. At one extreme, every company has a monopoly on the specific services issued with its name and address in the contracts and invoices. At the other extreme, all services are in competition with all other services for the resources of the consumers, who can always spend their resources in altogether different activities, provide for their own services, go to the black market, etc. So there is never really a monopoly. Is a trip in the same plane on a different seat a similar enough service to qualify as a competitive offer? Is a trip from a nearby airport similar enough? Is a trip by train similar to a trip on a plane? A trip by car? What about working or touring in nearby places instead of abroad? What about staying at home? Depending on the arbitrary answer to such questions, any single activity may or may not be tagged as a de facto monopoly. In other words, the concept of de facto monopoly is a fraud that can serve to assert whatever one wants, giving undue power to the authority that arbitrarily defines the similarity of services, and opening the door to a corrupt, oppressive government. Libertarians contend that this notion of de facto monopoly is at worst an absurdity, at best something utterly irrelevant, in all cases a fake alibi used to fool people into accepting government control on various services and industries. To libertarians, coercion in general and governments in particular are not a legitimate tool to work either towards or against such de facto monopolies. 2.3. An economic analysis of de facto monopolies. A monopoly, in fact, cannot ever take advantage of its situation to abuse consumers as long as there is freedom to compete in law. Indeed, as soon as it raises its prices such that its profit rate, that is, the difference between the income and the marginal production cost including investment amortization, is noticeably above the average rate in other industries, then capital will rush into competing firms to leverage such profit opportunities, cancelling any situation of de facto monopoly. Similarly, if the main or unique producer decreases the quality of its services in such a way that there is an unsatisfied market segment that could pay enough to generate above average profit by investing in the field, then new competitors will appear. Hence, as long as there is freedom for new competitors to enter the market, there is no situation in which enough people can legitimately feel harmed or wronged or unserved by the market. Freedom to compete implies that de facto monopolies have virtual competitors, even though they may have few or no actual competitors. In a free market, as characterized by the presence of freedom to compete, no company may ever extract arbitrarily high profits or undue profits from any so-called dominant position. If needed, the very people who think there is something wrong about the current state of the market, including any complaining customers, any disgruntled employee, any manager or investor of the current monopoly, etc., can invest in the field so as to propose their own services to better serve the needs of currently unsatisfied customers and potential customers. If their anticipation is correct, if indeed they can be better and cheaper than the de facto monopoly, amortization of the initial investment included, then they will indeed earn a lot of money, while fixing the wrong they felt existed. On the other hand, if their anticipation is incorrect, then they will lose their stake, and will thus prove how unfair was their claim about the monopoly making undue profits. In any case, freedom to compete means that people can be responsible for their own claims, reaping rewards when they are right, suffering losses when they are wrong. In other words, in a free market, there are no market failures, there are but market opportunities. An objection frequently raised by advocates of state intervention is that it is very difficult to raise large amounts of capital in a coordinated way, and that this gives an unfair advantage to big corporations possessing large infrastructures, so that they must be regulated by government. Actually, quite the opposite phenomenon is true. The difficulty of raising large amounts of capital is part of the transaction costs inevitable in any venture. Such transaction costs are included in the capital investment, the amortization of which is considered when evaluating the profit rate. But these costs are mostly unaffected by the size of the investment, and are thus a relatively smaller overhead for big ventures than they are for smaller enterprises. That is, they are all the less of a problem as the capital investment needed to compete is big. If the task is so difficult that not anyone can undertake it, then what appears as huge profits is but the just reward for hard work that no one else proved able to do. And if one brings benefits that no one else could otherwise bring, how can one be accused of depriving anyone else from what didn't, wouldn't, and couldn't exist without one's work? All in all, a de facto monopoly, just like any other company, and we saw there is no notion of de facto monopoly that can make any praxeological difference between two companies, can only remain in existence by constantly providing valuable service at affordable rates, without ever making an undue profit, without ever abusing from a so-called dominant position. Freedom to choose one's provider is what keeps everyone in check. Finally, if reasoning doesn't suffice, there is no historical record in any free market of dumping or concentration ever earning anyone undue profits, of ever permitting anyone to raise prices for any length of time above what they were prior to dumping or concentration. But there is record of companies maintaining low prices for extended periods of time without ever raising them above competition. There is record of concentration helping some companies keep prices low, and record of other cases where concentration didn't help and the concentrating conglomerate collapsed as consumers turned to other, smaller companies for their services. The only monopolies that can make undue profits and last are de jure monopolies, those that are supported by public force. And there is plenty of evidence for all the evils of monopolies as soon as de jure monopolies are considered. 2.4. An economic analysis of de jure monopolies. Whereas a de facto monopoly cannot levy any monopoly rent from its situation because of actual and virtual competition, a de jure monopoly can and will levy such a rent, because it can use the force of aggression of government to discourage or annihilate competitors. Indeed, inasmuch as consumers need a service monopolized by law, they would have to accept the conditions set forth by the monopolist provider, and if they cannot or will not accept these conditions, then they must live without the monopolized services, if possible and allowed by law. Often a de jure monopoly is established for a category of services that cannot be avoided, or is accompanied by an obligation to consume from the monopolist provider. Now each and every penny that a monopolist earns because of his de jure monopoly is by definition a penny that would otherwise not have been paid if competitors were allowed to enter the market, which implies that the public would have been served better and cheaper. Each such monopoly earned penny is thus the sign of an equivalent or greater destruction of riches as compared to what would have happened in a free market without state intervention in favour of the monopoly. The rent is precisely what motivates the monopoly to begin with. Theorists of patents, tariffs, monopolies, state subsidies, and all other kinds of protectionist and mercantilist policies use the incentive created by this very rent as the ultimate pseudo-utilitarian economic justification for their monopolies. If the laws had it that the direct and indirect benefits from monopoly were taxed away from the monopolist, you'd find that few monopolists still find monopoly attractive after all. However, law could hardly do that, since monopolies usually result in losses to the public and to the monopoly. And indeed, what we often see is massive direct and indirect subsidies from government in favour of its protected monopolies to keep them going, rather than taxes away from them to repay for the damages done. Monopolists thus clearly enjoy a rent from their destruction of riches, from their destruction of civilization. Companies that are without an official, obvious, explicit patent monopoly, but that somehow benefit from public force to compel customers or exclude competitors, are still de jure monopolies, even without the official name. And they are just as malicious as if they were openly admitted as such. Hence all the legal regulation that impose security requirements, government licensing, check by some special authority, all the so-called regulations and checks on the free market instituted by governments, are actually monopolies in hiding. They give citizens a false sense of security, and serve only to prevent competition towards different arrangements that would better fit the tastes of their consumers. Those laws exclude solutions that would be better for all concerned, and give an unfair advantage to those who are comparatively protected from the competition of those better solutions. The result may be a broad or narrow oligopoly, in fact, of government-sanctioned solutions, of government-licensed providers, or of people or institutions with some kind or another of government privilege, rather than a de facto monopoly. But the essence of the injustice is the same, and these de facto oligopolies are really sharing a de jure monopoly. 2.5. The dynamics of de jure monopolies. In contrast to de facto monopolies, the concept of de jure monopolies is not arbitrary. The question of whether a given company is a de jure monopoly doesn't rely on any arbitrary decision by a political institution. There is no need for any specific law or any government office to identify and fight such monopolies. On the contrary, such monopolies only exist because some laws and government offices protect the monopolists, to the detriment of reluctant consumers or of potential competitors. Fighting these monopolies is a matter of abolishing the protectionist laws, of stopping government intervention. It is not a matter of extending these laws and furthering this intervention. We already saw that not only do de jure monopolies exist in an obvious form whereby the government explicitly grants such a monopoly by laws excluding competition per se, they also exist in subtler forms of de jure monopoly, where the power to exclude competition and ransom customers is wielded by a corporation, a commission, a congress, or any public or private institution whatsoever. Government intervention, subventions, privileges, regulations, taxes, differential treatment, legal discriminations, and all pieces of legislation are indeed coercive destruction of riches that generate de jure monopolies. Often this intervention takes the form of laws enacted in the name of public welfare that limit the freedom to contract. The government forces certain transactions to take certain forms, with employers, landlords, retailers and others being bound to conditions not born from the mutual interests of exchangers. Minimal and maximal prices, minimal and maximal limitations in the schedule, duration, quality and other conditions of work, of housing, of retail, etc. Although these state regulations may give an apparent advantage to one side of the transaction, the long-term effects of such political privileges are not to the permanent advantage of the privileged party. Indeed, after a short term of adaptation by the market, such privileges will be internalized in the form of price, either monetary or non-monetary, attached to the acquisition of the privileged position. Thus, although some people do receive an immediate benefit from the enactment of political privileges, namely those who could acquire a privileged position while paying a price agreed before the privilege was established, latecomers, even though they are officially protected by law, do not get any advantage from it. The increased efforts through which they will have to earn their privileged position will be as much as the efforts needed to get the advantage from a free market, and the only thing brought by law is that they don't have the choice anymore to not pay for an advantage that they may not like at that price. Those rent seekers who initially lobbied for a regulation will reap benefits from the transition towards the protectionist system. But once established, and after a short transition period, the system will no longer bring them actual benefits, and will be only a hurdle detrimental to all concerned. Increase in visible revenues from protectionism correspond to a continuous overall destruction, whereas the actual opportunity gains are but a one-time premium earned during the transition period. In the long run, the global destruction due to protectionism in turn decreases the utility of all revenues, including those visibly inflated by the protection. However, the increase in short-term marginal utility to protectionists may be valued greater than the reduction of long-term utility by protectionism. Thus, people who are shorter-sighted will be interested in protectionism, to the detriment of everyone else, including their future selves. They will be similarly interested in spreading specific economic fallacies, and have some protectionist propaganda prevail, so that other people, under the false perception of a long-term gain from protectionism, will agree to government intervention. Rent seekers still have to work hard so as to constantly earn their share of the loot from transient protectionist gains. Indeed, convertibility of capital from one activity to the other, though it may be slowed by natural and legal hurdles, means that inasmuch as the activity of rent-seeking would be more, respectively less, profitable than other activities, then capital would flow to it, respectively from it, until the marginal return of investment is about the same in all activities, including rent-seeking. In other words, in the long run, even looters do not in the average benefit from the system of legal plunder. The marginal return on investment from their looting will not be substantially higher than that in the other industries. They will have to constantly struggle, maintain their army of men-at-arms, propagandists and courtiers, and all these expenses will not be substantially more productive to the rent-seekers than similar expenses in legitimate productive work are to honest entrepreneurs of the same country. Then why does rent-seeking persist beyond the initial stage of vastly profitable looting? Why do rent-seekers keep investing more and more in rent-seeking rather than convert to honest activities? Why don't they move to vastly more profitable looting opportunities? Why do they act to their own long-term detriment, when in the average they could as well invest in honest activities? Because although to their average interest, honest activities are to their marginal detriment. Indeed, rent-seekers have invested a lot in the destructive activity of looting. In accord with the natural specialization of tasks, rent-seeking is done mostly by people who are specialized in this activity. Their assets, their capital, is mainly invested in looting, and though part of it is convertible, a lot of it is immobilized or inconvertible, and all of this capital will lose its value if converted, so that even when an individual looter sells out, his capital is likely to be bought and used by another looter, old or new, who is more eager than the seller to use the capital in looting activities. All in all, there is a considerable amount of capital invested in looting that ensures that the vested interests of looters as such will be defended harshly whenever looting is put at risk by the libertarian ideals of justice. In conclusion, when government exerts its power to force people to do things, or when it prevents them from doing the things over which it forces its monopoly, the results are a momentary advantage to those who are privileged by this action or inaction to the detriment of others, and a permanent destruction of freedom and riches to the detriment of everyone, without advantage to the privileged. The momentariness of the advantage means that rent-seekers must earn their loot from continuously renewed lobbying being the activity remunerated by protectionism, which can be considered as a service sold by politicians to rent-seekers, with citizens being victims of a huge negative externality associated with this predation as opposed to production.